as we roll into the fall with our Elville webinar series. It's Wednesday, September 17th, all day. Our topic today is navigating estate and trust administration, and there's no one better to talk us through this discussion than our managing principal and lead attorney, Stephen Elville. Steve, how you doing today?
Good morning, Jeff. I'm really enjoying this cool weather, and you know we have to have rain, so
we do, but
yeah.
Not in the middle of the my daughter's soccer game last night. It was a hurricane out there, right in the middle.
No.
Got through it though.
I hope so.
A few housekeeping items. We always encourage your general questions, so please note them in the questions panel, and we'll pause periodically. And yesterday by email, you received the presentation slides and 2 checklists Steve is going to be referencing, and they're also available in the section marked handouts on your screen to download at this time. And everyone will also receive a post-webinar feedback email right after the presentation. Please take just a few minutes to fill out this brief yet important survey. Offer us your feedback about the presentation. And we also welcome some financial advisors to this presentation. 1.5 continuing education hours are available for most everyone that attends. So please tell me and send me your accreditation number and ID so I can submit your hours for approval and send certificates out. And a question for you. Have you achieved your planning goals, or have those goals shifted since you last looked at your planning? And here at Elville Associates, we want to be a resource for your family and you. If you have a new matter to address, if you're just starting out with planning, haven't looked at your documents for 20 years, which happens, perhaps an administration matter, whatever it may be, Steve and his team are here to guide you through the entire process and create solutions for you. So let's move through a real brief introduction, and then Steve's going to jump right into our material. So Elville Associates, we've been here for 15 years in Columbia. We have several different practice areas that we focus on, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We are quickly growing here, both here in Annapolis and in Rockville. Our mission, it's always been the same, no matter how big we get or how small we are, to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And you're going to hear the word education a lot here at Elville Associates and today. We do that in several different ways, including through our planning processes with our clients. And we have different programs to suit all families and individuals. We also have our educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program, I know we have a few client care program members on here today. Welcome. We're one of only 2 firms in Maryland to have a CCP, as we sometimes call it, accredited by the Client Care Academy in Boston. Just a bit about Steve as well. If you don't already know, how can you not know about Steve Elville? Well, Steve's work as an attorney for 25 years has been centered in elder law, special needs planning, and estate planning. He's a member of many different national professional organizations and peer groups, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, Wealth Council, peer groups, as I mentioned. Steve works to bring peace of mind to clients by offering solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker presenting at many different presentations, webinars, workshops, continuing education events each year. And Steve was named to the Maryland Super Lawyers list for a 10th time and 9th consecutive year in 2025. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charity that Steve founded in 2014. I'm very privileged to be a part of. If I were to switch my camera around here, I think last time I said there were about 30 instruments. There's probably about 40 plus since I picked them up from the band shop after being refurbished, and we continue to get more in. It's a busy time now that schools are in session. Got to make some deliveries all around Central Maryland and beyond in the next couple of weeks, but really one of my favorite parts of my job here at the charity and at Elville Associates. So if you want to learn more about it, please reach out to me. I would love to share our story with you. For now, Steve, I'm going to turn the reins over to you. Let's make you the presenter. There we go.
Okay, thank you so much, Jeff, for that kind introduction, and thank you for all that you do for our firm and our firm's charity and for our clients. And I'm getting my slideshow started here. And we're beginning on time this morning, and we're going to end on time for everyone who's present. I just have to make sure my screen is getting up where it's supposed to be. Jeff, I'm going to get it started, I promise. There we go. All right, well, thank you again, Jeff, and thanks to everyone for being with us on a very busy Wednesday morning. I know you have many things and many places you could be this morning. Wherever you are, welcome. I'm coming to you from Elville & Associates main office in Columbia, Maryland, in our conference room number 1, and I'm looking out at the cool rain that's falling, and I understand it's as west as Frederick and probably on the eastern shore as well. So we're happy to have our rain. It's a dry season that we need the rain, I guess, and hopefully you are having a great start of the fall and the holidays ahead. And we're going to get right down to business here this morning, but I first want to say a few words. I want to welcome everybody, including financial advisors, CPAs, and other insurance advisors, and our collaborative referral sources and partners that we work with, our clients, our client care program clients, new individuals who may have never watched one of our webinars. I just want you to be welcomed here, and remember that this is an informal presentation. If you have a question, please pose the question through the chat. Jeff will stop me if there's a significant question that needs to be answered. At the end, we may have some time to take questions. So that's our intention here today, is to educate, provide a path forward, and just know that whether you are in Central Maryland, in the Montgomery County area, in Prince George's County, Annapolis area, Eastern Shore, Baltimore, Western Maryland, Elville & Associates is here to help you and to provide our services through our Waypoint fiduciary services, which is our trust support and administration aspect of our firm. We do many things related to estate and trust administration. So just know my goal here today is to educate, but also to let you know that there are resources available to you if you need them. So with that said, I want to dedicate this webinar this morning to my sister, Tracy Elville. This is her birthday today, so happy birthday, Tracy, who is a 40-year nurse, head nurse at Anne Arundel Medical Center, and has done so many things for so many people. I just wanted to say happy birthday to my sister, Tracy, who has saved so many lives and is such a great nurse. Happy birthday. All right, as we get started, I recognize that some of you on this webinar may have lost a loved one recently. And if you have, we're sending our condolences and thoughts and prayers to you, because that's what this is all about, is that someone has passed away, an estate or trust has to be administered. So just be aware that we are sensitive to the fact that some of you may have lost a loved one recently and actually are looking for guidance about what to do. My goal today will be to explain how this process generally works and to provide at least some substantive information for you. And as we get started now, we need to remember this is not meant as legal advice, and we can enter into a legal attorney-client relationship, but this is high-level educational material and is not legal advice. Now, we're going to talk about what estate and trust administration really is. We're going to talk about some of the mystery that surrounds it and try to dispel some of that mystery. And estate and trust administration, let's be honest, is a very broad practice area. It's a very complex practice area when you get right down to it. And there's no way we can possibly cover all the material relating to estate and trust administration in 1 hour. But I'm going to give you an overview. We're going to talk about how to minimize confusion and how to support family members or clients if you're a professional on this webinar. And we're going to talk about legal step-by-step processes. Now remember, these are high-level overview. It's not really the specifics per se, but there are some specifics. What are the practical steps? What are the most significant problems that we see? And how personal representatives in an estate, trustees in a trust administration, financial advisors, CPAs, and attorneys, how can everybody best work together in an ideal way? If we had our preference, we would work together in certain ways that would be optimal. So we're going to talk about that as well. Now, before I really get into the substantive material, I just want to, again, couch this in terms of what will be success in this webinar for me, at least on this side of the screen, and what will be success for you, in my opinion? Well, hopefully you will walk away from this webinar understanding something that I'm going to be redundant about, which is that estate administration and trust administration is a process. It is a process-driven activity. I can tell you that from an attorney's point of view, from the private practice side of being an attorney, that administration is one of the more enjoyable aspects because it is a process. It does have its moments of unpredictability or chaos, but it generally is a process that most attorneys who engage in administration enjoy helping clients and enjoy that process. And for you, whether you use an attorney or engage them or engage a CPA or another professional to help you do administration at that time, when that time comes, one of the things that will make your life easier is to understand from the beginning that it is a process. And that if you are patient throughout this process, most of the time it's going to come out on the other side with the result that you're looking for. So process, being patient, being methodical. Okay, that's what I want to drive home. Now let's get started. So estate administration is one of our clients' greatest concerns. If you're a professional in this webinar, it's going to be one of your clients' greatest concerns. And with wills, by its very nature or by their very nature, there is a probate process. And with trusts, revocable trusts or other trusts that need to be terminated and administered, there is an administrative process as well. And there is what I would call a transitionary period. So understanding these foundational things are going to be some of the things we're talking about this morning. Who will be there for a surviving spouse if this person is married? If the person is not married, we know that there are many domestic partnerships and so forth. Who's going to be there for this surviving person or the surviving partner? Who's going to be there for the children? What is it that they should know that they should do next? A lot of people are completely stunned by the loss of a loved one. Of course, it's never predictable. Sometimes even if it is predictable, it's still a shock. So what should they do? Well, obviously, they should be driven by process, not circumstances. And this process is going to be a process in and of itself about the administration, which we're going to talk about, but it's also a process that can be planned for. And that's what Jeff had mentioned earlier. You know, how is the state of your planning right now? Have you had your planning updated? So we're going to kind of talk around all of that in one kind of session this morning. So we want process and so forth. Now, this slide mentions the handouts. And I want to just make one correction. In one of the handouts, one of the checklists, which I want you to know you have, at the bottom of one of the checklists, which is the critical dates checklist for estates, I want you to go all the way to the bottom, and it says that the portability election is 24 months. I want you to know that is not correct, and that needs to be corrected on your checklist. The portability election has to be done on the federal level within 60 months, 5 years. It used to be 24 months, and we're going to talk about that. But in Maryland, which if you are a Maryland resident, Maryland has portability. The district, to my understanding, the District of Columbia does not. But that portability election may need to be made within 9 months, depending on the size of your estate. But generally speaking, Maryland follows the federal. So I just want you to know the portability election on the federal level is 60 months, and in some cases in Maryland, it's 9 months. Now, I'm going to give you a few case examples. I don't want to really hammer hard on these cases or be confusing, but I do want to give you an idea of what people deal with in certain examples of what happens when someone dies. So I would just say sometimes the structure is very clear. That structure could be clear because the person did great planning, or it could be that the person just had a very simple situation, so the structure seems to be clear. Sometimes there are retirement assets in large quantities, which I know many people, many of our clients have. What's going to happen with those retirement assets? How are they going to be administered? What if there were non-probate assets like transferable and death assets that were driven a certain way? How do we deal with that? Sometimes we have a survivor, whether it's a surviving child or a spouse or a domestic partner, where the situation has changed, obviously, different than it was when the planning was actually done. And then we have, let's say, a fact-specific plan, which might be more of a chaos situation where there was no planning or poor planning. And sometimes, believe it or not, judgment calls have to be made by the fiduciary. So we're going to talk about a few of these, and let's just get into it. And I promise many of our webinar attendees in the past have asked that we not provide so much in-depth discussion about these specific fact patterns, but I think it's important to still cover some of them. So let's just look at this particular fact pattern. And I'm going to give you the summary version of this. Some of you are making notes on an old-fashioned piece of paper. Some of you are making notes mentally. Some of you are making notes on a pad, an iPad, or another tablet. Some of you have a computer. I would just encourage you to jot down things that jump out at you. There may be things you've never heard before that you might walk away with a little nugget. And let's get into this first pattern. So here we have someone who died with a will. This was a single man. He died with a will and left everything to his son outright. So we would say this is a very simple situation. It was a simple situation where he was a single person. He had a will. He left everything to his son with no further trust, no asset protection. Everything was outright to the son. So let's just look at these assets. His residence, if it was in his own name, he was 77 years old, is going to go through the probate process. Now, let me stop for a second. Some of you don't know what the probate process is, so let's just talk about it, and I'll just give you my description of it. The probate process is what happens if I die with a will and I have assets like this residence that is in my sole name. It is a sole asset in my sole name with no joint owner and no beneficiary. So this residence is going to go through probate, and depending on the type of probate, Maryland is a traditional probate estate, as is North Carolina, my understanding is, Delaware, New York, Virginia has some streamlined probate for those of you who are Virginia residents or have family in Virginia. But here, let's just assume this gentleman was in Maryland. In a typical regular estate, this is going to take about 9 months to probate. Sometimes there is a streamlined version of that can be done. Maybe that would happen here. Checking savings, CDs, $200,000 in this person's own name. Let's assume it was not joint. Let's assume it was not transferable or payable on death. That's going to go through probate. IRAs, if this was a beneficiary designated asset, no probate, and that's going to go to Charles by beneficiary designation. This is the son. And we know Charles probably is healthy and well from what we see here. And he will have to take that inherited IRA within 10 years. This is the new rule under the Secure Act. And let's pretend that this gentleman who passed away, that he had all these savings bonds in his own name. That would mean these are subject to probate, and these are also called IRD, income in respect to a decedent. So there's going to be income tax on these, and it's going to have to be decided how that income tax is going to be paid. Should it be attributable to the person who died on their final tax return? Should it be attributable to the estate, or should some of it be attributable to the son? So there are ways of thinking about how that income tax should be allocated. Here, there were no creditors, there were no lifetime gifts. So this is a simple example of probate. Now, what if Felix, who is the gentleman who passed away, what if he never had a will? He would still have probate under these circumstances because he would have been considered to have died intestate without a will. So whether he has a will or not, he would have probate for those certain assets that we just discussed. Now let's quickly go to another fact pattern. This is a couple. Many of you on this webinar are couples. You are married, you have children, or sometimes maybe you don't have children in your situation. This is a situation where if you look down to the bottom of this slide, there is a revocable trust. Now, what is a revocable trust? A revocable trust is an alternative to a will. It is a an estate plan that is a private estate plan that is basically a contract, a private contract. It is a substitute for a will. And a revocable trust has two steps. You create the trust and then fund the trust. That means putting the non-retirement assets of the couple into a joint trust or two separate trusts, depending on how they've done it. So here we have a couple, 3 children, they're aging in place. Now one of them has died. There was a residence, and let's just assume that was in the trust. There was checking, savings, and CDs, meaning cash. Let's presume those assets were in the trust. There were joint brokerage accounts. If I skip over the 401k for a second, there were joint brokerage account. Let's assume those were in the trust, or that was in the trust. Now back to the retirement plan. There are retirement plans, and let's just assume this was a traditional couple. They left all the IRAs and 401ks to the survivor, who then rolled them over to their own IRA, and they had asset protection. You can see from the pattern here, neither of them has reached full retirement age for RMDs. So the survivor rolled this over. Here, we could have had a situation where the deceased spouse left an IRA to a marital trust or to a non-marital trust. That's beyond the scope of today's discussion, but let's just assume everything went to the survivor. There was life insurance. There is a separate residence in Delaware, let's say a second home, and here there were no lifetime gifts. So here we have a situation where everything goes to the survivor, because if you look at the bottom of the page, everything was outright to the survivor, and there was no probate on the first death. But now look at the bottom of the page. What if the estate planning documents had not provided for an outright distribution? Perhaps on the death of only one spouse, there was a non-marital or marital trust that would have to be created. And again, that subject is beyond the scope of today's discussion. But just to give you a feel that on the death of one spouse in this situation, it doesn't look like, assuming that beneficiary designations have been made, it doesn't look like there's any probate on the first death. So what we want to take away from this is a couple of things. Most of the time in a traditional couple situation or with revocable trust, there's not going to be any probate if everything is done appropriately. There's not going to be probate until the second death. And here, because it's a revocable trust, there will not be any probate at the second death either, because that's the purpose of the revocable trust. Now, here we don't see anything going to anyone who is subject to inheritance tax of 10% in Maryland. Remember, Maryland is one of the only states that has an estate tax for state purposes and an inheritance tax, but we don't see anything here going to anyone except the survivor, so there's no inheritance tax to worry about. And what other thing jumps out at us? Well, the surviving spouse, here Janet, is going to want to make the portability election. So portability has to do with being able to move or port the deceased spouse's exemption amount. Right now, $13,990,000. To move that over to the surviving spouse, in this case, Janet, and Maryland's exemption right now is $5 million, and to move that $5 million over to Janet, so that depending on how much the exemption is when she passes away, there is going to be almost 28 million of exemption and 10 million of exemption for Maryland because of the portability concept. Portability is not appropriate for all couples, but in this case, it looks like portability might be the best idea, which it's going to be for 80% of people or more. And so we have the portability election, which Janet needs to do within 9 months for Maryland, if we are watching carefully about the assets, and 60 months overall for federal. Okay, so this is kind of fact pattern number 2. Now, fact pattern 3 briefly is similar, except now Janet has died some 20 years later. Her assets have increased. Her deposit at the continuing care retirement community could be such that it's coming back to the trust, because if it was a situation where a refund of the deposit, which is not always the case, But if there is a refund of the deposit, we're going to be looking out for that. We have no probate because she was very, very purposeful, and she made sure that there was nothing going to be in her probate estate. So no probate on the first death, no probate on the second death, because the revocable trust or trusts were fully funded. And look down here, we see a Florida residence now. She has sold the Delaware residence. She's got a Florida residence, but she made sure that was also non-probate. And so there's no ancillary probate in Florida. And we see that there were no lifetime gifts. However, look at this now. There were several creditors, which is a little bit unusual, but Janet, let's say, enjoyed going to casinos, or she ran up a bunch of credit card debt. Now, this is probably not going to happen, but let's just play this out. Here we have her, the surviving spouse with a revocable trust. Can creditors make a claim against a revocable trust? And the answer is yes. According to the 2014 Maryland Trust Act, creditors can make a claim against a revocable trust. I personally have never seen it, but what would be a best practice here for Janet's surviving successor trustee, the person who is going to now administer the estate, the trust estate, now that Janet has passed away? And this is the bigger administration, remember. This is where the successor trustee is going to administer the trust and eventually account for everything and distribute everything to the 3 children, okay? So the best practice, of course, is to account for everything, make sure that there's a final accounting provided to all beneficiaries, and to fulfill their fiduciary obligations, okay? But now we see that we have to deal with a situation where we're looking at those creditors, and that person is going to want to run notice to creditors. They're going to want to do something which is authorized by law in the 2014 Act, where they can notify creditors and hopefully put out that if the creditors don't make a claim within 6 months, that they are forever barred from making a claim. So these are the little nuances that are best practices, even though most people who are older and die in these circumstances are not going to have a lot of creditors. Look at the other thing here that's in the fact pattern. One of the children is now disabled. Now, in past years, when I gave this webinar and used the same example, we would talk about how the surviving successor trustee would be able to make a discretionary decision about whether to distribute these assets outright, which is what this says, or to be able to distribute this disabled child's assets into a special needs trust that was a standby document provided for in the revocable trust. The problem with that is that some revocable trusts don't provide for standby provisions, which of course a lot of modern documents like the ones we use do provide for these flexible standby provisions. This child has had a brain injury. Nobody could have anticipated that, and now Janet died. What's going to happen with this person's share? Well, I'm happy to say that if you are administering a trust or an estate, and there is someone who has a disability and it was never anticipated, and that person was to receive a share outright, or that person was to receive a share in a regular support trust, a trust where their assets would not be preserved for public benefit purposes, because now this person has an injury and they need to be on public benefits. Well, the good news I can tell you now is that Maryland has had a decanting statute. Yes, decanting, which is at the bottom, and that is a really wonderful thing that we finally have decanting, which is the ability to take that person's share and make sure that it is decanted into a supplemental needs trust to protect them, even if the document itself does not provide it. So if you're not familiar with decanting, we have a webinar on that, and if you have an hour of your time that you can watch it, you can become more familiar with it. But thank goodness about 2 years ago, Maryland has implemented a very nice decanting law, and we do not have to depend on decanting in Virginia or Delaware unless the circumstances were to dictate that we needed to use that jurisdiction. The last fact pattern is the one where there's a factual set of circumstances here that are just really not that great. This gentleman was, he died. He had a will. Well, actually, I apologize. He did not have any will. This fact pattern says he died without a will, so he died intestate. He was separated from his spouse, not divorced, and the children are going to receive through intestacy. And remember that he's got a very odd set of circumstances here. I have actually seen this in my practice before. And there's no protection for the children who are going to receive certain shares through the intestacy laws. One of the children is in bankruptcy. That could really mess up their share and they might lose it to creditors. He had made lifetime gifts during his life, but that's not a problem, generally speaking, because he had a $13,990,000 lifetime exemption for estate tax, meaning at his death, or gifting during life, okay? Now, let's go back to the beginning of these assets. He had checking and savings. That's going to go through probate because that was in his own name. He had an inherited IRA that he received and was taking distributions on. Now, the children are going to receive, or if he did not beneficiary designate further beneficiaries, those are going to be accelerated as far as income tax and go to the estate. He had an automobile that will go through an estate here, probate. He had life insurance with no beneficiary. What happens to life insurance with no beneficiary? It goes through the estate. He had savings bonds that obviously will go through the estate. We talked about that in an earlier example. So here we have several issues. We have the fact that the intestacy law is going to determine how much the surviving spouse gets. There's going to be no asset protection for her, no control at all in this estate plan. So this is obviously where we don't want to be for ourselves or for our children or loved ones, where we die without a will. But this is an intestacy type situation. And I guess the only good news here is that it doesn't seem like this gentleman has creditors himself. So it doesn't look like creditors would be able to attack his estate. All right, so at this point, we're about 30 minutes into the presentation. Jeff, I'll just stop and ask if there's any questions at all, and I'm going to get into now the more non-example related portion of the presentation, and we'll get into some best practices and what to watch out for practically and legally.
Thanks, Steve. No questions as of yet.
Very good. All right, I know we're digging deep there into a subject that is very unpleasant in a way to talk about. So thanks for hanging in there with me. Grab your second or third cup of coffee or tea, and we'll go forward. Now let's talk about how do we kind of minimize confusion and provide support to our clients or our loved ones. Well, first of all, we need to have a significant amount of empathy, and this may not seem like something that should even be mentioned, and it would just be a given, but I can tell you that not all professionals and not all family members have as much empathy, especially on the professional side. So we as professionals need to put ourselves in our clients and fiduciary situation and have empathy. There is, I cannot overstate this enough. It makes a huge difference at a time of crisis to provide that support and to determine bullet point number 2 here, what kind of support does the family need, and to make sure you're trying to render that kind of support. Remember that if you're a professional on this Zoom call, you should be a resource center, especially if you are an elder law or estate planning attorney. Your whole firm, or if it's a family situation, your whole family obviously should be involved. Hopefully there's harmony and cohesiveness in the family at a time of crisis. Be creative, again, about resources, and have the ability to refer to a counselor or coordinator or life care manager or hospice, or act as a coordinator or mediator yourself. Now, we want to assure clients or fiduciaries that are clients that they should be taking care of themselves first. Oftentimes, in practice, I see surviving spouses, particularly, that will take it upon themselves to instantly come in and try to trudge through some very, very difficult material, administration, get the process started, when there's really no reason for them to do that, no reason for them to be doing anything except taking care of themselves. And this can't be overstated. It is not necessary in most cases to come in and put yourself through a very painful discussion when you've just lost a spouse or other loved one. Now, with that said, there are circumstances where this is essential. There could be rental real estate. There could be bursting of pipes and other problems. There could be tenant issues. There could be a business that is still running after someone passes away. So there are exceptions, but generally speaking, let's take care of ourselves first. We want to make sure that the client and the advisors, that they are all notified and are coordinating together. Now, by the way, you're going to see that beneficiaries are entitled to notice and information, but this is a different thing. To make sure that an advisory team is there and all coordinating together at this time of crisis. We want to assure clients and fiduciaries that things are in order, or that they have specific steps about how to make sure things are in order. We're dealing with a situation right now where someone had passed away, unfortunately, and their loved one in another state is really scrambling. And we are trying to make sure they are provided with as much support and resources as possible. We need to make sure that funds are available. This situation I just described is similar to where this person is wondering how funds will be available, and we need to work together to make that happen. Final arrangements and making sure that those get paid for. Are there other family-related issues that need to be addressed where there's not harmony among the family members or some other issue? And of course, nothing can take the place of a sympathy bouquet of flowers or other instructions that someone might leave to say, this is what I want to happen, charitable contributions, whatever it may be, in lieu of flowers or bouquet of flowers. But the impact of these things is lifelong. No one can underestimate the power of your empathy at this time. Now let's talk about legal issues. Having just talked about some practical issues, let's talk about legal issues, probate versus non-probate, meaning wills versus revocable trusts. Similar steps, but different processes. Sometimes similar in process, sometimes not. This is something I want you to walk away with, that even if you are administering a trust, there still should be what? A process. And you should use checklists. Now, the Register of Wills has checklists. Lawyers can provide checklists. The one that you've been provided is just a sample, but organization obviously is the key. Now, let's talk about this legal step-by-step process. And remember, this is a very high-level overview. This is not specifically the legal step-by-step in reality, but it's close. But just be aware that this list is not exclusive. So, a death certificate is issued. This is what usually gets a process started. Sometimes death certificates are quick, sometimes they are not. Letters of administration in probate estates. This is what we're talking about here, probate. Someone died with a will, or someone died without a will and still had probate assets. That's what we're talking about here. A letter of administration to give you the official authority as the personal representative to take control of the assets of the estate. An inventory and information report is due in a regular estate within 3 months, and this has to do with what are the values. When you open a regular estate, the Register of Wills in Maryland will not necessarily demand to know the exact value of everything, but 3 months later, we are expected to provide appraisals and substantiate the value. Information report wants to know what? Is anyone subject to inheritance tax? So there are 4 questions on that information report. You need to provide those answers because the Register of Wills collects inheritance tax. Now, usually this is not the case, but what happens if we need an alternate valuation date? You just need to consider that. Are there any claims against the estate? Those of you who are not familiar with this need to know that we have an estate search that you can go on. The Register of Wills, Maryland, go into estate search and you can see right online, this wonderful system that will give you an idea of what's going on in the estate and have there been any claims? What is the process? What is the docket? What is happening? You can see that at Estate Search. Now, there are spousal elections. There is something called the new spousal elective share, which is a formulaic approach to how much a surviving spouse is allowed or is allowed by law to have if they did not receive at least 1/3, and it's a slight fractional formula of a little bit more than 1/3. Disclaimers, which are still being used, even though we have portability, which is a blanket of exemption. There could be the need for a surviving spouse to disclaim an asset or another beneficiary to disclaim. But a surviving spouse has to disclaim for federal estate tax purposes within 9 months. And of course, estate tax returns are due within 9 months. And remember that estate tax, if it's payable, you need to at least make an estimated payment for estate tax within 9 months, but it can be extended to 15 months. The Q-tip election, which is the qualified terminal interest property election, for those who are going to leave assets in a marital Q-tip trust, that has to be done within 15 months. The good news is that can be done on the same form as the portability election. The portability election is made on Form 706 and Form MET1 for Maryland. The Q-tip election is made on the Form 706. Portability has to be done within 5 years. The federal government has made this date so long that a lot of people are going to forget it. I would urge most clients to elect portability within 9 months and get it over with, because some Maryland residents are going to have to make the Maryland portability election within 9 months. Why not just get it done and make sure that if you're going to elect portability, you get it done and you get it done soon so you don't forget it. There are timelines for the first and second administration account, second, if there is a second administration account, and subsequent information accounts or administrative accounts. Personal representatives basically get released from liability when the court approves the final account, and there are no exceptions. In a trust administration, which we're going to talk about in a minute, a trustee is allowed to be released from liability where the beneficiaries are going to sign off and consent at that they have seen the accounting, everything is transparent, and they can be released. Retirement plan accounts have to be claimed within a certain period of time. This is something that you're going to want to be on top of. And of course, you're going to want to be aware of the Secure Act, and the Secure Act meaning the 10-year rule for most people, but there's 5 exceptions to the Secure Act. Spouses, beneficiaries that are less than 10 years younger than the plan participant, children who are less than 20, or beneficiaries, I should say, that are not more than 21 years of age, and then disabled people and their special needs trust, chronically ill people and their special needs trust. Except for those 5 exceptions, everyone else who receives an inherited IRA is going to pay the tax within 10 years. This is just something you need to be aware of. Now, let's continue this. The income tax returns for the fiduciary estate, the 1041 and the Maryland 504, those are due. You're going to want to work with your attorney or CPA about the tax years, the fiscal or other calendar tax year. You're going to want to be on top of these things, including closing letters with IRS about income tax or estate tax, and about whether amended returns can be filed. Now let's switch over, in the interest of time, quickly to the process of what would happen if you are administering a revocable trust, which, if it's properly funded, this is a non-probate distribution. So we still have to get date of death values, and you're going to see this list. So let's stop right here. Remember that with a revocable trust that is properly funded, upon the last beneficiaries or last grantor's death, let's say it was a surviving spouse, the assets of that revocable trust can be distributed immediately. There is no probate, that can be distributed immediately. Very powerful. But a smart trustee is not going to do that. Why? because they are going to get date of death values and establish the step-up and basis for real estate through an appraisal. They're going to notify beneficiaries. Qualified beneficiaries are entitled to notice since 2014. Is there going to be a notice to creditors? Remember, we talked about best practices. Even though you might say, well, there's no creditors for the deceased. Well, maybe still go through the exercise of notifying creditors to limit the potential for creditors' claims against a trust. And you'll notice these same elections, the spousal election, okay? And this is another change, and Jeff, we need to make sure we note this change. The new spousal elective share has happened, and so we need to be aware that spouses have access to what is called the augmented estate. So remember, in a trust administration, we have non-probate assets, but in the new spousal elective share law, those spouses who are not receiving at least a formulaic 1/3, that spouse is authorized to make an elective share claim against lots of non-probate assets, not just probate assets as it used to be in the past. So we do have a new spousal elective share in Maryland. The Q-tip election, the portability election, all those things remain the same. Disclaimers. What I want you to take away from this slide is, even with an administration for a trust, there is still a process that should be followed, even though the trustee is not jumping through hoops with the Register of Wills, because this administration takes place outside the Register of Wills process. Now, I mentioned the release, waiver, and refunding agreement that a trustee is entitled to be signed by beneficiaries. And if you are a trustee administering a trust, I would strongly recommend you do not distribute the assets to the beneficiaries. Even though you have no reason to believe anyone is unhappy, I would not do that unless they sign off and say they have seen and are happy with the accounting, you have been transparent, and so forth. I would not give them money until they have signed off. You are entitled to that. The rest is a duplicate of the other processes for final tax returns and so forth, closing letters. These things I want you to take away. The estate administration process to the Register of Wills is scripted. The trust administration process is also something that is there, although it is not under the auspices of the Register of Wills. Now, real quickly, let's say that there is just one beneficiary and a surviving grantor of a revocable trust. Well, there's no one for this person to account to. It's just them. They are the only beneficiary. They are the trustee of the trust. Well, that's a very powerful technique. The person who died, the beneficiary can distribute all the assets to themselves immediately, but there are still some very basic things they should do and be concerned about: journaling over brokerage account assets to the stepped up value, making sure they get an appraisal, and of course, there could be a taxable estate or some kind of inheritance tax that's due. So we have to just be mindful that there are still processes and things to be concerned about, even if you have a revocable trust. Now, what are practical steps? Continue, schedule a meeting with the surviving spouse if you are a professional or other fiduciary within 30 days. I don't think it has to be within 5 days, 2 days, 10 days, but certainly within 30 days, we want to start the process, with some exceptions for rental real estate and other more expedited circumstances. Coordinate with your other advisors if you are a professional on this call. Use checklists. Organizing is the key. Keeping the client, the family, the fiduciary, helping them be organized and really understand what their responsibility is. And I'm going to stop here for just a second. Can you imagine being a personal representative of an estate or a trustee under a trust administration, not understanding your duties, and we see this all the time, and you do not provide the notices required by law, you do not provide the information that's required by law. There is no such thing as a quiet trust in Maryland. Beneficiaries are entitled to notice, they're entitled to information, but let's pretend the person doesn't provide that. They can be removed. This could be a very nice person, a very good person, a very sincere person, but they did not fulfill their fiduciary duty. and they could be removed. Can you imagine anything more painful or embarrassing to put yourself in that position? So seek legal advice to at least understand your responsibilities for information and notice. You want to have an inclusive process, in my opinion. Now, every administration has its nuances. Every administration has different beneficiaries. However, even with, let's say, less than pleasant beneficiaries or troublesome beneficiaries, you're going to want to measure, and maybe this is with legal advice, how much information to share above and beyond the basics, or how inclusive to be in the process. And it's going to be a judgment call about whether or not a troublesome or difficult beneficiary should have more inclusion or not. But you want to be sensitive to that, because if this person brings litigation or other things against the estate, and weigh that, the costs and the trouble. So these are some of the navigational challenges that sometimes arise in administration. You want a reasonable due diligence with making sure people are doing what they're supposed to be doing, encouraging them, but not hurrying them. And again, the surviving spouse in a spousal or partner situation is going to want to do their own planning. And of course, we know, unfortunately, that the death of a loved one sometimes triggers folks to do their own estate planning or to update it. But again, having dealt with many, many surviving spouses, I can tell you they do not need to do it so quickly that it is a painful experience in and of itself, because these are very, very difficult times a person is going through. So again, being redundant, organization and general readiness is going to be your friend and the friend of your loved one who might die. We want documents to be stored where they are available. We want digital assets to at least be on some kind of spreadsheet. And now we know we've got cryptocurrency and other things that we need to be aware of in administration. Do we have access to statements and policies and so forth? Do we have access to physical savings bonds or stock certificates of the old kind where they used to be, actually distributed out? Did the person who died have Everplans or other electronic archives? And can you get access to that? Well, the answer is yes, because as a personal representative or trustee, the Digital Assets Act says you have the ability to get into those, but hopefully there has been some kind of a facilitation of the access codes and so forth for you. But just know that even if you do not have access to those codes, you are authorized to be able to access the digital assets of the deceased person. Now let's talk about, in the last few minutes, what are some of the most significant problems legally and tax-wise? Well, we want to review the titling of assets prior to death. You've seen this, we see this very often. Someone's lifespan is limited, God forbid, and now especially we want to make sure things are revisited, titling is revisited, but let's pretend it's not an emergency circumstance, which is what we want. We want all estate plans to be funded properly. If it's a will plan, we want to make sure beneficiary designated assets are correctly beneficiary designated. If it is a trust plan, we want to make sure that the trust is properly funded. For you financial advisors on the call, remember that TOD, or transferable on death, is not necessarily the appropriate funding tool for a revocable trust. So we want to work together to assure that asset alignment is correct prior to passing. The valuation of all assets after death. This is something I've mentioned a few times. Getting the date of death values. This is an important thing in almost all trust and estate administration. After a spouse dies, we want to be careful, and I'm going to speak to our financial advisor friends on this webinar. We want to be careful about the quick retitling of accounts in the name of the surviving spouse, including life insurance, because even though the exemption amounts have gone very high, and in 2026, under the new tax bill, we're going to have 15 million of exemption for each spouse. Even though these exemptions are very, very high at an unprecedented level, so are assets very high at an unprecedented level for most people. So you do not want to retitle accounts for your clients or surviving spouses. You do not want to retitle accounts quickly until there's been a consultation with your lawyer, your CPA, and your advisor, really looking at these assets, because we have to follow what the estate planning documents of the deceased spouse say happens. Are there certain post-death trusts for spouses that are supposed to be funded? Are there other provisions that are supposed to be funded rather than just retitling everything in the name of the surviving spouse? Are there things that need to happen, like a disclaimer or the portability election in general? But the point is to use your common sense and due diligence after the death of a spouse, and not automatically retitle or accept all proceeds until there's been a meeting of the minds. Inheritance tax issues, we talked about this. Portability election, Q-tip election. All these things are things that need to be put on a timeline and affected and facilitated after someone passes away, if it's applicable. Failure to foreclose creditors' claims. This is a problem. So again, best practice is to notify creditors, and in an estate, creditors are notified. Real quickly, back to inheritance tax and portability elections and Q-tip elections. These are problems, right? Because if you don't make the Register of Wills aware that someone is subject to inheritance tax, there can be severe penalties. The portability election can be lost if it's not timely, especially on the Maryland level. And Q-tip elections for marital trusts have to be done within a certain period of time. Again, being redundant, we want the entire advisory team, hopefully there is one, to communicate. We want to determine who's going to quarterback that team. We want to invest significant time during clients' lives, or during your life if you're an individual or couple on this call, to make sure things are aligned properly. If there is an illness, and I alluded to this earlier, we have to assume sooner than later that we've got to get things done sooner than later. Many times individuals who are ill pass away sooner than we may think, as unfortunate as that is. And we want to ascertain wishes, encourage the use of memorandums of intent, and so forth. So how can clients, advisors, CPAs, attorneys, trustees, how can everybody best work together? Again, encouraging each other with advanced organizational tools. Make yourself look at these tools, and they will be available to you, I promise. Encourage education of your family members and fiduciaries who may be family members. Facilitate a systematic method where things will be organized. If you're using a corporate trustee, you want to do your due diligence about how that corporate trustee deals with situations after the death of someone. We want to disseminate information and assure and instill confidence in everyone involved. So Jeff, I promised I would end on time, and I think we will. I want to encourage everyone on the call to congratulate yourself for sitting through that on a Wednesday morning. That's a ton of information I'm throwing out there. My purpose was to try to illustrate problems and the major ones that are associated, bring those to your attention, including the portability election and so forth. Also to make sure you're aware that planning is a process during life. Administration is a process after death, including administration of a trust versus an estate. There are still administrative items. There's nothing to fear if you would like to talk about this. Even an attorney-client meeting is subject to the attorney-client privilege. Everything is confidential. If you have documents you haven't reviewed for years, we are happy to review documents. If you don't have a financial advisor or a CPA, we're happy to help you form what I would call the advisory team, including an insurance professional. You may have a lot of questions you need answered. We're here to look at your questions, your list of questions, and to try to provide answers. I'd say after COVID and now in the complex world we're living in, what we take pride in is counseling, client care, and giving the client and or fiduciaries time to think. And that is what is something that a lot of people don't really have a lot of time to do, is actually think. Thank you, Jeff. Thank you, everyone, for being here this morning. I'm going to turn it over to Jeff again, and I hope you have a wonderful week.
Well, thanks, Steve. Very important information, as always. Let's pause for just a question or two here, and now's a great time to get your final questions in, Steve. And we do have one, Steve, which I'll pull up here. One of our CPA friends here has posed this question. How do you address tax reporting that needs to be delayed because the assets are abroad and in litigation?
Oh, wow, that's a great question. Well, I don't have the answer off the top of my head, but I think what we would want to do is, speak to IRS and speak to the comptroller. And again, I can't answer that off the top of my head, but try to effectuate some kind of a hold period. And of course, I think the client sounds like they would be a U.S. citizen. We'd want them to sign a power of attorney form that we could talk to IRS behind the scenes. But that sounds like a very unique situation. And of course, I don't know what country the litigation is in. And that's another issue, whether it is a common law country or a civil law country. And so I think it's fact specific, but happy to try to advise on that.
Thank you. So a few comments thanking us for being here today. Thank you for being here. Without you, we don't have a webinar series. We're grateful to have you here. And we have some more coming up. I'm going to go through those in a second. I also always send out the video, the slides again, the checklist that Steve mentioned, and some other substantive information that should be of help to you. As far as our webinar series going forward, we've got a few coming up, including next Tuesday evening. We have our semi-annual retirement series with Timic Financial, and Steve's going to be talking about estate planning and elder law essentials on the 23rd at 7 o'clock. Then we have on Wednesday the 8th, our wellness series comes back with Dr. Michelle Fritsch. 5 common myths and strategies you can implement tonight about sleep. And like I said last time, who couldn't use a little bit more sleep, right? And restful sleep for that matter. And then October 8th, we'll be doing the second part of our presentation series with Mark Timic, another estate planning and elder law essentials with Steve on October 8th at 7 o'clock. And we have our client events, last but certainly not least, October 18th. We have some spots still available, so we'd love to see you. Last day to RSVP is on October 1st at the beautiful, completely refurbished Ten Oaks Ballroom in Clarksville. We'll be talking about the evolution of estate planning in an ever-changing world. And you have Steve and Billy Hummel, our principal attorney in Rockville, and a great team of people offering some presentations, great food, lots of fellowship, door prizes, music from the Columbia Orchestra. It's going to be a great time, and hope to see you there. So we'll look for any final questions, and if not, we'll call it a good day here, Steve.
Thank you, Jeff, and everyone.
We have a couple here. Can you explain surviving spouse trustee journaling assets to stepped up basis?
Yes, thank you for that question. So if I understand your question correctly, I'm just referring to something that your professional financial advisor is going to do as part of the inheriting of assets that come over to a surviving spouse, or at the death of a spouse, a surviving spouse, how the assets will be journaled up to the stepped up basis at the death of both spouses. Now, there are times when a surviving spouse is going to have an asset like some stock in their own sole name. Many of you have this situation. And that stock is going to get a 100% step up in basis at death. So the idea of the cost basis adjustment under the IRS code, which we still enjoy in this country, thank goodness, is that sometimes there's a 50% cost basis adjustment, sometimes there's a 100% cost basis adjustment, as in community property states, or in the situation I just described where someone dies with the asset in their own name. Remember, the retirement plan assets like IRAs do not get a step up in basis, but other non-retirement assets do. And depending on how they're owned, it's going to be 50% or 100%. What I was referring to is, as part of the administration process, your financial advisory firm or the one for the decedent is going to want to journal over, meaning make sure those assets get a new fair market value on the books of the securities and brokerage firm, so that the beneficiaries, if they sell those assets, they do not have to pay capital gain.
Okay. And one more final one, then we'll end on time here. How is fiscal year defined?
That is a very good question. So your CPA, in some circumstances, is going to, they're going to advise, depending on the situation, depending on what's a will, an estate, or whether it's a trust. They're going to advise whether there should be a fiscal tax year, meaning a tax year that begins at a certain quarter or month, versus a calendar year. So that's going to be a judgment call about whether or not it's a will or trust, and whether or not there are tax advantages to having the fiscal year instead of a calendar year.
Okay. Steve, great education as always. Thanks
Thank
to
you,
you,
Jeff.
you out there, and we'll see you again soon on the Elville webinar series. Have a great rest of the week.